Hello guys, and welcome to another episode of my lecture. On today's lecture, we'll be talking about share qualification of directors. So let's get straight to the class. So when we talk about share qualification of directors, the very important section for us to get to is section 277 of Cama. And what does section 277 of Cama say? It says that the shareholding qualification for directors may be fixed by the articles of association of the company, and unless so fixed, no shareholding qualification shall be required. Now, this means ordinarily an appointed director need not be a shareholder. It is left for the articles to impose condition of shareholding for individuals to be appointed as a director. This means that this is a default provision. So when we are talking about share qualification, a director need not be a shareholder in a company. It is only when the article so requires that a director holds certain number of shares, that is when this particular provision will be binding on such director. In the event that the article is silent as to the number of shares to be held by directors, then this particular provision will not be binding on such directors. It says here that the law does not impose the requirement that directors should also be shareholders. It instead leaves it in the hands of company to insist on membership for directors. That's very, very important. Then we go to the second subsection, which says that it is the duty of every director who is by the articles of the company required to hold a specified share qualification, and who is not already so qualified, to obtain that qualification within 2 months after his appointment. Now, you should know that if you do not have that particular qualification, the share qualification, according to the articles, you can still be appointed de jure. Do you understand? But the act mandates you to have it by the end of the 2nd month after your appointment. If you are appointed 1st January and then you are supposed to have at least 10% of the shares of a company as a director, if you don't have it on 1st of January, it's fine. If you don't have it 15th of January, it's fine. 30th of January, it's fine. But by the end of February, which is going to be the end of the 2nd month, if you don't have it, then it means that you would automatically no longer be a director. Why did I say that? Let us go to subsection 3. It says that the office of director of a company is vacated if the director does not within 2 months from the date of his appointment obtain his qualification, or after the expiration of the said period he ceases at any time to hold his shareholding qualification. Now, what does this mean? It tells you that immediately after 2 months expires, if you don't have it, your office is vacated. You cease to become a director. Also, it tells us that if you have it after 2 months have expired, it's fine. It means that you continue to be a director. But before your period of office, if you cease to have it, the moment you cease to have it, your office as well ceases. Look at what it says again. Let's read the provision. It tells us that the office of the director is vacated if the director does not within 2 months from the date of his appointment obtain his share qualification. So if you are appointed 1st January, you must obtain your share qualification at least by the ending of February. Do you understand that? Or after the expiration of the said period. So after February, he ceases at any time to hold his share qualification. If at February you had it, but in August you lost it, in August you cease to be a director. If you continue acting as a director even after you have been disqualified because you cease to hold the required share, then you are no longer a de jure director but a de facto director. Do you understand? That is what the provision of section 277 subsection 3 is telling us. And section 277 subsection 4 tells us that a person vacating office under this section is incapable of being reappointed as a director of a company until he has obtained his shareholding qualification. This particular provision is answering a particular question. You see, some people ask, okay, what if in August he lost his share qualification, but then he got it back in September? Does he then resume to become a de jure director again? The answer is no. He has to be reappointed to become a de jure director, because when you read the provisions of 2772 and 2773, it tells us that at any time when he loses his shareholding qualification, he automatically ceases to be a director. Now let us read what section 2774 says again. It says a person vacating office under this section is incapable of being reappointed, which means that there must be a reappointment. But before such reappointment can be done, he must have his share qualification again. Until such reappointment is done, if he continues to act in the position of the director, that is, directing and managing the business of the company, he is no longer de jure, but now a de facto director. Do you understand? So with that, we have interrogated the provision that says that a person who is to hold a directorship position must have share qualification. That is, if the article says so. If the article doesn't say so, then the director need not have share qualification. Do you understand that? However, we've looked at the provision of subsection 1, subsection 2, subsection 3, and subsection 4 of section 277. In my next class, we'll be talking about the duty of the director to disclose his age, as well as whether or not is a director of any other company. Also, we will be talking about appointment of director for life. I will see you in my next class.